Analyst on land, gender, politics and cultural issues. Thanks so much for your time on SABC News. So this act is supposed to be about the recognition of king and queenship. It's about the recognition of the Khoi-San community. Can you explain to us more?
Well, I mean, there's one of the things that it does, for the first time, we have a piece of legislation that actually recognizes the leadership of the Khoi and the San people in the same way that it recognizes the leadership of African people. And I think that is a very good development. However, there are issues with the bill, and that's what I would like to talk about. For 16 years now, communities have engaged in conversations with government, in protest, engaging with Parliament, Constitutional Court, all these kinds of forums, to try and address the differentiated rights that were brought about by when the first bill which came out was the Traditional Leadership and Governance Framework Act of 2003, which the President has also signed. Now, the key issue here is that this bill, the TKLP, the one that we're talking about, has got sections that render it unconstitutional. The one that I would like to talk about, because it's related to another law that government has not signed, even though they were instructed to do so by Parliament. Section in this bill is Section 23. Deals with the powers of traditional leaders and the rural communities, particularly in relation to communal land rights. In Section 23, it says that they should consult IPILRA. IPILRA is the Interim Protection for Informal Land Rights. And these rights are the rights that affect people who live in rural communities. They are communal land rights. The rights that say people who live in rural areas, who live in customary land, who live in their ancestral land, that their rights are recognized by the Constitution, that they cannot be dispossessed or dislocated from those from that property. This bill does not protect those rights. The Constitution, Section 25(6) E of the Constitution, says Parliament must enact a piece of legislation to recognize and to protect the rights of people who were dispossessed, who have unprotected rights. Government has not done that. In 2010, the Constitutional Court ruled on the Communal Land Rights Act that the Communal Land Rights Act was in fact undermining the rights of these communities that I'm talking about. Okay. And that they were supposed, as the Constitution says, they should enact this law, and the Constitutional Court said government must actually come up with this legislation. They have not done that. In 2010, this is 9 years. Instead, what they do, they go and enact another legislation, which in fact undermines the rights of these people. Okay,
there's a concern with these types of laws. I know this is an issue that came up similarly when it comes to the Ingonyama Trust, when people perhaps have their constitutional law or their constitutional rights to land, for example, being placed in the hands of communal and community leaders. The part that people are also saying, though, is that this is the first time, as you've said, that people are recognized, the Khoi-San community is given autonomy. How then do you balance that, knowing that the Constitution is our supreme law?
Well, firstly, it's not our fault that it's the first time, and they're not given autonomy. They are recognized. And the thing is, it is not either you recognize the leadership, the traditional leadership, the Khoi-San leadership, and all these institutions. It's not either that recognition of those institutions and on the other side, the rights of communities. It doesn't have to be either or. And government projects itself. And here, particularly President Cyril Ramaphosa, when he spoke at the funeral of the king yesterday, he says he has always stood with traditional leaders. There's a suggestion that often is made by politicians and traditional leaders that people who question the fact that rights of communities are being made to be vulnerable, that they are against the institution. So we're not saying don't recognize the institution. We're not saying do not recognize the leadership of the Khoi-San. We're saying do not pit these institutions, these rights, against each other. Mm-hmm. We do not have to say we either choose traditional leaders at the expense of rights of people. We're saying the constitutions make clear provisions for this. And President Ramaphosa did not have to sign this bill. He could have sent it back to Parliament and raised the questions that were raised by the former President Motlanthe high-level panel. Questions that are very fundamental, actually, in relation, for example, to the Ingonyama Trust. Ingonyama Trust charges people land, lease for land. People have got to rent the land, their ancestral land, because the rights are insecure. The informal rights, what is called informal rights, the informal rights are not protected. Instead of President Ramaphosa addressing this, he went and apologized to King Zwelithini. And as a result, the conversation about what Ingonyama Trust is doing, it died. We are saying that he could have sent this bill back to Parliament and said, there are constitutional issues that have been raised. Could you please help me? Or he could have even asked the Constitutional Court for its wisdom and say, there's a bill in front of me. And these are the issues. We've got to recognize traditional leadership, African traditional leadership. We've got to recognize Khoi-San. We have to do all these things because they are supposed to do that constitutionally. But these are the constitutional issues that are coming up. He didn't do that. And I'll tell you why, before you close. This is a political choice. Ramaphosa has chosen, together with his ministers and the MPs, they have chosen that there's a hierarchy of rights in this country, and that rural people who live in communal areas, who are dispossessed of their land, who have been abused of their rights, who lived under Bantustans, which are introduced by this bill, that those people, their rights don't matter.
So my question is, when this bill is now signed and assented to, what happens next? If you want to challenge these issues that you're raising of the constitutionality, how can that be changed, if at all?
Well, what is going to happen is that poor communities, as they have always done, they are going to have to ensure that government does what it is supposed to do, that it meets its obligation and enact laws that are in line with the Constitution. So conversations are taking place and will take place about taking this bill to the Constitutional Court. But I'm saying that even if that remedy exists, it's a burden that is unjust, and it's a burden that is unnecessary to impose on people.
With this bill, with the very problematic issues that you've raised, there are also parts of it, like the establishment of a national house, which seems to be something that tries to work in line with what government is doing, to cooperate with the provincial houses, to deal with peace, stability and nation building. So there are parts of the act that seem like they would be helpful. Do those also need to get thrown out, or just the problematic ones? Listen. This bill is not going to apply to you here in Johannesburg. The peace part of it, even the National House, you have a right to decide whether you're interested or not interested. Okay? So all the issues that are all the provisions that are in the bill, whether you talk about the role of traditional leaders in reconciliation and all of that, these are things that happen in traditional communities. You cannot have a law that says these are the good things that are going to happen, but over and above the evidence, mountains of evidence that have shown that a number of traditional leaders, not all of them, but a substantive number of traditional leaders abuse their powers. They abuse their resources. They enter into deals, as you saw, between the Mapong and Lonmin, deals that do not benefit their communities. As you saw, Lonmin got away with everything, and they ensured that agreement went ahead, because what you have is an elite pact.
And it's an elite pact, whether the elites are the traditional leaders, whether they are the politicians, whether they are people like me, middle-class people who want to go and build businesses. And that's what we're saying, is that what is the stake in terms of the rights that have been abrogated by this piece of legislation undermines any positive aspects that it can have. So this is what will happen. As soon as notification is introduced that the bill is challenged on grounds of constitutionality, it will not be implemented. The President also signed another bill, the Traditional Leadership and Governance Framework Act, an amendment to it. And that amendment addresses a number of things, including the establishment of traditional councils. In 2003, when that bill was signed into law, it said traditional councils must have 30% elected members as women, and 30% of the people who are in the traditional council should be elected from the community and should not come from traditional leadership families. Parliament is aware of the fact that traditional leaders have not, a number of traditional councils have not actually abided by this provision. So they've signed the TLGFA so that they can get away with the fact that this law now relies on that. So in 16 years, there's not a single instance where the Department of Rural Development, or in fact the Department of COGTA, where COGTA has ever entered into a conversation with traditional leaders, with traditional councils that do not have 30% women, that do not have 30% elected representatives in 16 years. And instead of addressing all these issues first and making sure that when the law is applied, it's applied in an environment where traditional leaders can be seen as people who can reconcile communities, where they can be seen as people who can make decisions, or who can go out and consult and be known to be representing their communities. Instead of addressing those issues, instead of addressing the elephant in the room, which is Ingonyama Trust, and the way in which Ingonyama Trust is abusing the powers that it has and intimidating anybody who dares raise those issues, both in KwaZulu-Natal and in the Republic in general. Instead of addressing those issues, they have taken a political decision. Ramaphosa has taken a political decision that he will appease traditional leaders at the expense of the rural majority, and that is a problem.
Thank you so much for your time on The Full View this evening. Nomboniso Gasa, researcher and analyst on land, gender, politics and cultural issues, joining me in studio there. Now, parts of the country are experiencing sweltering heat. Temperatures in Mpumalanga's Lowveld are exceeding 40 degrees Celsius. Water parks and street vendors are taking advantage of the heat wave, and they're cashing in as people try and cool off.
Splashing about in a pool, arguably one of the best and fun way to stay cool. High temperatures coupled with humidity have seen hundreds flocking to Mbombela's water park.
I'm from Secunda. This heat is unbearable.